Today we're discussing two principles, Principle 20 and Principle 21, having to do with majority rule and strong local self-government. First of all, I want to ask you this question about this document, the Articles of Confederation. Do you know, and we've talked about some weaknesses of the Articles, but do you know, I don't think we've mentioned this one, another weakness of the Article when it pertains to majority rule. What was it? What did it require in order for any vote to be effective?
Everybody.
That's correct. It required unanimous decision, unanimous vote. Well, what does that mean? That every state has to agree, and if one state doesn't agree, what happens to the vote? It fails. Can you think of what that means further? That means one state could what? Could prevent something from happening. Just one state. Why do you think they would put that kind of a rule in the Articles? Anybody got any ideas? I want you to think back in the colonies in those days, in the colonial period. And it's much different, the thinking about government, than it is today. Today, when you say government, you think of what? Usually, the federal government, something in Washington. When they said government then, they focused on their states. There was a very strong loyalty to state government and states' rights. And there was a strong feeling that they didn't want anybody telling their state what to do. If their state didn't agree with it, they weren't going to do it. And that feeling was so prevalent that it reflected itself in the Articles of Confederation, that every decision that the Union makes has to be unanimous, meaning every state has to go along with it. You're not going to force any state to do anything against their will. And as long as they were united in fighting off King George, that was kind of okay, because they knew everybody was united in doing that, right? But down the road, after you win the war, and you don't have your independence to fight for anymore, all of a sudden other problems begin to manifest themselves. Do you see that situation? So a single state could prevent change. And this is particularly a problem when there's a what? When there's an emergency, some kind of crisis. Particularly in the area of politics. You're hardly ever going to get unanimity. So we're going to talk about this whole idea of unanimous consent. And I want you to turn, well, go to the bottom of the first page of the 20th principle. That's page 229. And let's read a little more of John Locke as he talks about this concept of majority rule. You with me down at the very bottom? He says, when any number of men have consented to make one community or government, they are thereby presently incorporated and make one body politic, wherein the majority have a right to act and conclude or bind the rest. It being one body, he says, it is necessary the body should move that way whither the greater force carries it, which is the consent of the majority. Or else it is impossible it should act or continue one body. What's he saying here? Well, let's just finish this last part. And thus every man, by consenting with others to make one body politic under one government, puts himself under an obligation to every one of that society to submit to the determination of the majority and to be concluded by it. What's he saying? If you agree to live in a community, and let me ask you this, young people, do you agree? Do you agree to live in this community? In this nation? Yes, even if it's by default. You didn't come here from another country. So you didn't really have that choice, but by default you agreed to live here because you're free to what? You're free to go somewhere else. So we all agree to live here, And by living here, we have agreed that we will abide by the consent of the majority. Everybody follow that? That's quite an obligation, isn't it? We just got to make sure that the majority makes the right choices. And they usually do, we find out about people. Not always, but usually. Okay? Locke said it was impossible to get unanimous consent. And here's how he says it in the next quote there on page 230. He says, if the consent of the majority shall not in reason be received as the act of the whole, nothing but the consent of every individual can make anything to be the act of the whole. In other words, it's either got to be the majority or what? Or unanimous. Then he goes on to say why unanimity isn't too practical. He says, which considering the infirmities of health and avocations of business, which will necessarily keep many away from the public assembly, and a variety of opinions and contrariety of interests which unavoidably happen in all collections of men, it is next to impossible ever to be had. What's he saying about unanimous consent? It's impossible. Somebody's going to be sick and not able to go vote. Somebody's not going to be interested. They're going to have other interests. Plus the fact that even if everybody's there, you're hardly ever going to get unanimity of opinion in politics. So he says this is so impractical. The only other alternative is a majority. So I ask you this question, and let me draw a little bit here on the board. Let's assume that this represents the body politic, okay? And let's divide it in half. Let me ask you, what is a majority here? How can I make this a majority? By doing what? What is the definition of majority? Half plus one. One what? One vote. And it could be just a very small sliver of this part added to this part would give a majority, right? And so we generally call it what percentage? 51%. Okay? Now, so this is great. This is 51%. Now let me ask you this, and some people have said this. Matter of fact, he says it right there. If 51% is good, then maybe 52 is better? How about 53, 54? How about this? What would that be about? Maybe 2/3, 67%. Would that be even better? You would think. Or how about this? If 67% is better, how about this? 75%. Wouldn't that be a great rule? Everything's got to be done by at least 75%. What do you think? That's not, all of a sudden we got some negatives here? 67% you said was okay, but 75 is not. What happened? Well, you still got 25% of the people who could disagree. What problem do you see here? And here's the problem that John Locke points out. What? Yeah, the closer you get to unanimity, the more chance you have of what? Let me just illustrate it here. Let's assume that this is 25%, right, down to this line. Let's assume that 26% would vote no, and you required 75% approval to do something. What power have you just given this minority? The power to negate the will of the majority of the people. And is there just one minority here? How many minorities can you get out of this whole body politic? You could get several, right? So one minority may be against this, another minority may be against that, another minority may be against that. You see the problem here? And you are giving power to a minority to stop the will of the majority. So John Locke said, in the traditional, normal business of government, you've got to keep it to a simple majority, 51%. Do you all understand that? Let's read on page 231. This is Alexander Hamilton in the Federalist Papers. He says, to give a minority a negative upon the majority, which is always the case, where more than a majority is requisite to a decision, like 2/3 or 3/4, it, in its tendency to subject the sense of the greater number to that of the lesser number, that's what it will do. The necessity of unanimity in public bodies, or something approaching towards it, has been founded upon a supposition that it would contribute to security. Then he goes on to say, not necessarily so, because the minority then can control. Do you all understand this? That's why 51%, just a little over half the majority. How many majorities are there? It's only one. Okay? It's only one majority. And John Locke says that majority then is what moves the body politic. Okay? So, for those who say 51%, then why not 67 or 75? You have your answer. Now let me ask you this. Are there times when you want a supermajority? When you want 67 or 75%? There are times you may want that? Yes, and the founders said yes, there are very special times when you may want that. Can anybody think of a time that's required in the Constitution? If you're going to override the president's veto, it's required what? What's required there? 2/3. See, that doesn't happen very often, but if you really want it, it's got to be 2/3. Same way with amending the Constitution, 2/3 of Congress, and then 3/4 of the states have to approve it. If you're going to change this precious document, it's got to be by an overwhelming consensus. So every once in a while it requires that. But the normal business of government, just a majority. If we do it otherwise, a small group could hold the whole body hostage. It gives the minority a negative upon the majority, and then the minority is in control. Well, let me ask you this question. In government, should you always have the people, or a minority, subjected to the will of the majority? Let me ask you that. Always. Let me pose this scenario. Do you think the majority could pass a bad law? Oh, yes. But if it's 51%, if it's a majority, do we just have to deal with it? What have we learned in the past? Until it's changed, you deal with it. And it can be changed at the next election, or it can be changed at the next session of Congress. That's fine. But let me ask you this question. What if an individual is accused of a crime using a law that may be questionable, maybe even a bad law? How does that individual or that small minority defend itself against the tyranny of a majority? Do you think that could ever happen? Oh yes, the founders warned it could happen. How? Somebody tell me. We've talked about this a little bit. How could the majority hurt the minority? You think that through? What if the majority of people were poor and a minority were wealthy and everything worked by majority vote? How could the majority hurt the minority? Yeah, the majority could vote to take away the property through taxes of the minority. What do you say about that? Well, majority rules. That's the way it's got to be. You going to stand for that? No, even though the principle of majority rule is very sacred in a republic, there must exist what? Something to protect what? The rights of the minorities, which are the same rights everybody has really, but just because they're in the minority, you've got to have something to protect them. And what do you have? What protects the rights of minorities? 18th principle. First of all, you have to have written laws. You have to have your principles of government written down so that if the majority passes a bad law and it gets applied to a few people, those few people can say, hey, wait a minute, this is against a principle of good government. Do you all see that? Where is this kind of problem usually adjudicated, usually taken care of? In the where? What branch? In the judiciary. In the judiciary. So I want to tell you about the concept of jury. When a person is brought for violating a law into a courtroom, and he has his case, and the government has its case, the prosecutor has its case. If you're sitting on a jury, and you hear both cases, both sides of the issue, here today is what most judges will instruct the jury. I've sat on a number of juries, I've heard it said, and here's what a judge usually will say. Today, I want you to get this and then compare that with what I'm going to tell you in a minute. Judge will usually say something like this. Ladies and gentlemen of the jury, you've heard the facts, which means you've heard both sides of the case here, right? Both cases, defendant and prosecution. You've heard the facts. Now I will tell you the law. Your responsibility is to decide the facts based upon the law that I will give you. So you go into the deliberation room thinking that your responsibility is to do what? Decide whether the guy did it or not, right? Based upon the facts that were presented to you in the case. You go in there thinking that it's your job to decide the facts, whether the guy did it or not. Now let me tell you what many judges, including the first Supreme Court Justice John Jay, explained to the jury in the first jury trial, and this was for the first 100 years or so in the United States. This is what he would say, something like this. Ladies and gentlemen of the jury, or sometimes it would only be, in the early times, it would only be gentlemen of the jury. You have heard the facts of the case. In other words, you've heard both sides. Now I will tell you the law. I hope you give deference to my experience in the law. But you don't have to. Because your responsibility is to decide both the facts, which means whether the guy did it or not, and the law. What's the difference here? Pick up that difference? The jury has a responsibility to decide the law. The jury, in this kind of jury, has a responsibility to decide whether that law should be applied to this case or not. And if the jury decides, hey, this is a bad law, or jury may decide, you know, this prosecutor is so zealous in getting this guy convicted for some reason. It's almost a personal vendetta or something. He's misapplying the law here. The jury can return a verdict of not guilty, even if the guy did what he's accused of doing. But perhaps the jury decides, this law should not be applied to this person at this time. Not guilty, Your Honor. What do you think? Is that a way of protecting an individual, a minority, his rights against an unjust law or an unjust prosecutor? Yes. And I submit to you, this is a powerful protection in the Constitution. We call this a common law jury. And this was the case for the most part up until about 1896, which we'll learn later in the semester, when the Supreme Court said, a judge doesn't have to tell you your full duties as a juror. He doesn't have to tell you you can make a decision based upon the law. And so most of them don't nowadays. So you go in the deliberation room innocently thinking all you can do is decide whether the guy did it or not. Wasn't so in early America. Do you see the difference here? Do you see the powerful protection of a common law jury for the minority rights of the individual? Hope you see that. Okay?